Support comes from Missouri Forest Products Association, committed to sustainable and sound conservation of the state's forests, which support more than 41,000 Missouri jobs, resulting in a $10 billion industry. ChooseWood.com.
From St. Louis Public Radio. This is St. Louis on the Air.
I'm Elaine Cha. On November 8th, 53% of Missourians said yes to Amendment 3, a measure to decriminalize the sale, consumption, and manufacturing of marijuana for adult use. Part of that amendment included provision for clearing certain cannabis-related criminal charges from people's records. The amendment went into effect on December 8th, and there are plenty of questions folks have not only about what these automatic expungements encompass, but also how will it actually work? Later in the show, we'll also take up the impact of cannabis legalization in the workplace. But we'll kick off this Amendment 3 follow-up with expungement. And here in studio to address that is John Payne, the Legal Missouri campaign director who oversaw the winning ballot initiative and served the same role when Missouri legalized medical marijuana in 2018. John, welcome.
Thanks, Elaine. Good to be here.
And we have Matt Schmidt, an attorney and assistant public defender recently based in St. Louis and now working in Cape Girardeau. Thank you both for joining today's show.
Absolutely.
Good to be here.
John, you were the campaign manager of Legal Missouri's ballot initiative Amendment 3, and a big piece of that win isn't just the promise of anybody 21 and older buying legal cannabis, it's clearing convictions of folks who right now have criminal records for cannabis. Give us the basics. What does Amendment 3 say about expungements, and what does that mean practically now that it is passed?
Yeah, so Amendment 3 enacts the broadest expungement that has ever been passed on marijuana in the country. And it orders the courts to expunge automatically all nonviolent marijuana offenses. There is an order in which they have to do those things. So, for instance, the misdemeanors are supposed to be expunged within the first 6 months. Then the felony offenses that are eligible within the first year, and I believe it's A, B, C, and D felonies of over 3 pounds. Those are expunged upon the completion of that person's sentence. But all the other ones, even if they're actively serving the sentence, those are eligible for expungement pretty much right off the bat.
And you said 3 pounds?
Yes.
Okay.
Yeah.
Matt, just this weekend, you held a clinic to help people with cannabis convictions who are looking to get those records erased. In what ways are these convictions for cannabis possession holding them back in life?
Well, there's a variety of sort of state benefits and things, including student loans, some welfare programs that people could have. But most of the people that I've talked to who are not currently serving a sentence or on probation are more concerned about getting that off their record for jobs. One lady who came to the clinic told me that she had been passed over for a job because the city just didn't respond to the background check fast enough because she had sort of old marijuana charges here. So I think that's the main concern for people I've talked to who are not currently serving anything or on paper.
Mm-hmm. And
is, jobs.
Out of curiosity, about how old was the woman that you were just speaking about?
Oh, I would say late 20s. Late
20s. Okay, so still relatively young, with a lot of life both behind her and ahead of her.
Yeah, and there's some sort of mythology. I think people don't want to admit what we've done, but she had previously served a 60-day sentence for marijuana, so people get locked up and put in jail for it all the time.
Right.
Or used to.
And as John has just explained, the expungement is automatic under the way that Amendment 3 was written. And there are, as John mentioned, deadlines built in for misdemeanors. So say you have a misdemeanor for possession of cannabis on your record, and in real life effect that you've just told us about is that it could keep you from getting certain kinds of employment. And under the new law, the court where you were convicted is supposed to go back to its records on its own and erase it from all records. And the court itself is supposed to do that by June 8th, 2023, which is 6 months from the date that Amendment 3 took effect. Now, when it comes to cannabis-related felonies, which have broader and more serious consequences than misdemeanors do, courts are expected to do the same clearing, though they've got until December 8th, 23, which is 12 months to complete that. So again, you've just done this clinic, and the courts are supposed to do this expungement. You're helping people petition the court on their own. Why is that?
Well, in cases of people who are have an old charge and stuff, we're not actually filing the expungement paperwork. I've talked with our court clerks here, and as you keep saying those deadlines, but they're starting now, and so the purpose of my clinic was sort of to gather people who sort of needed it urgently and may not know how to do this. And if you're in a different county and you've got this problem, I would call up the court clerk of where you were charged and explain it to them, and they may do you first. So it's more of a matter of like skipping the line for some people.
Okay, and taking some initiative to do that.
Right.
Right. Now, John, in an interview with the Missouri Independent earlier this month, Stephen Sokoloff, the general counsel for the Missouri Office of Prosecution Services, he talked about the expungement deadlines that are set down by Amendment 3 and said that he doubted the deadlines could be met and called them a procedural, quote, nightmare for the courts. What do you think of that characterization?
Well, I think Stephen Sokoloff probably doesn't want those deadlines to be met because he opposed the amendment in the first place. But they are aggressive. And this is going to be a lot of work for the courts. When I say that the expungements are automatic, I mean they're automatic for the people who are getting the records expunged. But there's absolutely nothing automatic about it for the courts. Mm-hmm. They have to go in, and particularly on the felonies, the misdemeanors are relatively straightforward because there's actually a statute that is possession of marijuana under 35 grams. That's a misdemeanor offense. All the felony offenses are just classified as possession of a controlled substance, and that could be, when you just see that charge, that could be marijuana, that could be cocaine, that could be methamphetamine, or it could be some combination of any group of controlled substances. And so in those cases, the courts are really going to have to go in and look at the factual basis of the case and say, okay, yes, this one is purely just marijuana, and so we can expunge that. But if it's some other drug, then that's not going to be eligible for expungement.
So those distinctions then, do you see those as being part of some of the complications that would hinder the courts from making the June 8th and December 8th expungement deadlines?
Yeah, I'm less worried about the June 8th one because that's all the misdemeanors. Those are pretty straightforward in terms of—
And it's really the felonies.
Yeah, the felonies will be more complicated. Now, the flip side of that, though, is there are fewer of them. The vast, vast, vast majority of these cases are misdemeanor. Mm-hmm. So it's the felony cases that will require more research. But, the thing is that the courts have requested a supplementary budget to do this. And, from everything I've seen, it seems like that's going to get approved, but obviously that we're just at the beginning of that process. The legislature won't be back in session until January, but that should provide them the resources to get the job done within the timeline.
Mm-hmm. Now, back in 2018, Missouri voters passed a ballot initiative that legalized medical marijuana. That initiative did not include expungements. What is it that motivated the 2020 campaign to include that expungement piece, and how did it arrive at its final version?
Yes, I mean, we really did want to include something on that. Just all the stakeholders thought it was an important issue. But, when you're drafting a ballot initiative, there's kind of a few things that you have to look at. There's, okay, what do we think is the best policy? And then what will the voters support? And fortunately, those things lined up in this case. The voters were very strongly in support of expungement. However, it was also clear in our polling that voters they didn't just want everything expunged all at once for no matter what the offense level it was. So we had to draw some distinctions in there.
Okay.
And so exactly where we drew those lines, that was, kind of a contentious, those could be contentious conversations because there was always people that wanted to push it farther and then other people that said, hey, no one was really against that in principle, but it was the further we push this, the more we risk the whole thing, because it's not, when these things go up for a vote, it's not as if there's a line item veto for the voters. It's an up or down vote on the whole thing. And so any unpopular provision in there can cause the whole thing to founder. And so that was really the trade-off that we were looking at, trying to push it as far as possible within the bounds of public opinion.
And whom did your polling include?
So, it was a random sample of, I believe, 800 Missouri voters, and that it's you try to get a good cross section of demographics in the state, and I think it proved reliable because as we tracked the polling through the process, we ended up pretty close to where our final polling was.
Mm-hmm. And I do want to emphasize that we're speaking in St. Louis, but this is statewide.
Yeah. I mean, if it was just the city of St. Louis that was in the poll, it probably would have been very different and could have been a very, very broad initiative. But, we won 73% of the votes here in the city of St. Louis and about 60% in the county. But then once you get kind of into more southern or northern Missouri, there are relatively few counties that we carried out there.
Okay. And Matt, you are in Cape Girardeau. We'd like to know what you've been seeing. So it's not just expungements where this change in the law is making a difference. What is it that you're seeing inside courtrooms? Have judges already stopped charging people for cannabis-related crimes?
It's been pretty great up and down. The day after the vote, the Wednesday, the prosecutors dropped the 2 felony marijuana cases that I had. So it basically took effect immediately because they just realized we could draw those out until the deadline. And then on the 8th itself, December 8th, when the law came in, I saw the first guy come in on a marijuana charge, and he was on probation for that. And they were getting to the part where they talk about revoking his probation. He gets to ask for a public defender, so I started paying attention. And then the judge realized the underlying charge was marijuana and just let him go right there. So for a lot of these things, if you're on probation right now and the charge hasn't been cleared, if you get a violation and get in a courtroom, the judge is just going to dismiss it there. So we're seeing basically every day for the past couple of weeks a bunch of charges get dismissed and dropped one way or another.
So the effects were immediate.
Right.
Yeah. Well, we are going to take a very quick break here, but we'll be back shortly to continue the conversation. We've been talking about the expungement of marijuana convictions brought on by the passage this past November of Amendment 3. This is St. Louis on the Air on St. Louis Public Radio. Welcome back. I'm Elaine Cha. We're talking about the changes in Missouri law now that recreational cannabis is legal. We've heard from John Payne, who managed the campaign that voters approved to change Missouri's constitution, and from Matt Schmidt, an assistant public defender who's watching how the new law is playing out in courtrooms. There's another group that's tuning into this process with keen interest, employers and their workers. And joining our roundtable to talk about that area is Brian Pezza. Brian is an employment and labor attorney at the St. Louis law firm Lewis Rice. Brian, welcome to the show.
Thank you for having me.
What are some of the most common questions you're hearing from employers who are trying to figure out what to do about their workers and legal cannabis?
Probably the most common question that I've heard has just to do with the basic question of whether they can continue to prohibit the possession and use of marijuana among their employees while at work or while performing work if they're not at an employer location. That answer is fortunately quite clear, and the answer is yes. You can continue to prohibit that, as most employers' policies have done. And from there, we get a number of other questions that are somewhat idiosyncratic depending on the type of employer who's asking the question.
Mm-hmm. Can you give us an example of what a couple of those quirks might be by industry?
Sure. Largely, it depends on two things. One, they would go down a safety road where they have employees who are somehow in a safety-sensitive position, or who may operate equipment or may drive vehicles that certainly you can't do while intoxicated, whether it be marijuana or any other substance. And the other is employers who are really struggling to find workers, period, and they want to know what this change is going to do with their drug testing policies. It may do at pre-hire, many of whom have already been becoming more lenient, and some stopped testing for marijuana even before the passage of the amendment. But those are the two types of questions that we've been hearing. And of course, sometimes in, say, manufacturing in particular, both of the questions overlap, and we have the same employer expressing the same concerns.
Mm-hmm. And do you think that pertains mostly, the concerns, to issues around liability?
I think so. I think people are always worried about, when it comes to safety in particular, worried about what's going to happen if some accident were to happen at the workplace, when all of a sudden there is now focus on the particular employee and all the circumstances that led to it, and whether the employer had done enough to protect both that employee and any others who may be affected, where liability could certainly fall as a result. Also, I think they're concerned about what kind of what they might lose by way of government funding, if they're a government contractor, for instance, or if they have requirements for their own customers to make sure that their employees are drug free. How do the legalization impact their obligations to both the federal government on the one hand and perhaps their customers on another?
Mm-hmm. And speaking of the federal government, you've mentioned that some employers, like those who deal with transportation, they're federally mandated to perform drug tests on their workers to make sure they're not impaired. Has that changed at all?
It has not. With respect to, I should be clear that with respect to recreational marijuana, employers still have great latitude to test and to take adverse action in this much the same manner as they had done before. But one important part of Amendment 3 was to expand protections for employees who have medical clearance from their physicians to use marijuana. And in that instance, there is a carve-out from the anti-discrimination provisions that are new to Amendment 3 for employers who would lose some financial benefit or licensure under a federal law or a federal grant program, because, of course, marijuana is still illegal under federal law.
Right. Now, other employers in construction, energy, and healthcare, they may not do such testing to adhere to federal mandates, but nonetheless administer drug tests pretty regularly. What changes have you seen there, if there are any?
Well, to the extent there are licensure issues where perhaps a license would require that someone periodically be tested, even outside of the federal context, I think the issue, if the employee who needs to maintain a license can't maintain the license, then they may have an adverse experience at work, an adverse employment action, because of the loss of the license, which is not something that the employer can necessarily control. So it may be a case in healthcare. I've heard that specifically with respect to certain security guards, for instance, who have to have maybe a local permit, and that permit requires drug testing that may or may not have adapted yet for Amendment 3.
Mm-hmm. Now, are some employers simply moving away from drug testing for cannabis? We've been talking about the legal aspects of it, but clearly if voters have voted to approve Amendment 3, there has also been a cultural shift. Is moving away from drug testing for cannabis a trend that started maybe even before Amendment 3 passed?
Absolutely. And I think that goes to the question of the labor shortage as much as anything with in many industries, where if employers continued to screen out potential employees and applicants based upon marijuana convictions, they're shrinking the pool of the available workforce beyond what their needs would allow. So that's the first place I've seen where employers began to stop testing and become more lenient over the past couple of years. And certainly I'm sure that the passage of the legalization of medical marijuana in 2018 certainly accelerated that, and that's what I had seen. And we're certainly seeing that far more now, both from a policy perspective based upon the cultural shift, as you noted, but probably more pragmatically because of the need to have the broadest labor pool that they can possibly have in these tight labor markets.
Mm-hmm. Now, I do realize that your work focuses explicitly on the employer side of things, but it would be great to get some perspective from the worker side. Are there protections in place for employees who say, hey, my employer cut my hours or fired me because I was using weed or enjoying edibles legally during my off hours?
Well, I think the question the question that I would have for that individual is it because of a medical need and for which you have a medical card or not? And if not, then Amendment 3 doesn't provide much of a firm protection, and I'm not sure exactly how I would advise that person, other than to say that if you're going to be making those kinds of decisions and you're currently employed, before you decide to partake, take a look at what your current employer's policies are. And hopefully, if the employer has available policies that they've published, you can do that and see whether it's currently prohibited. And from there, make an informed decision about what you're going to do with your recreational time. Now, if you have a medical need, well, then you have many more rights now than you did prior to December 8th. And I would suggest that for most circumstances, it would be treated, I would speak to that person much the same way as I would for anyone with any disability that would be protected under federal or state disability laws, so it's with respect to accommodation or otherwise. And I would recommend that person be upfront with their employer when and if it becomes an issue, and be very clear about the medical need that they have, and disclose as appropriate their medical marijuana card.
John, as we're talking about employees, can you tell us about what the new employee protections are and why they were added?
Yeah, so essentially what the amendment says is that if you're a medical marijuana patient with the card from the state and you are using medical marijuana outside of the job, so not on the premises, not while you're working, but in your own personal time, that outside of some of the narrow exceptions that were outlined earlier, you cannot be fired or refused. They can't refuse to hire you, cut your hours, take those adverse actions against you legally at this point. So that those are some new protections, and we felt like that was appropriate because for someone who has a medical marijuana card, that's someone who has a medical need for marijuana, and so it's not it would not be fair for them to be treated harmed by their employer simply for that fact. And obviously there are safety concerns about being impaired on the job, and so those things are restricted still. But we did think that this is a good way to put in protections for people that have a medical need for marijuana, but certainly don't want to lose their job over it.
And Matt, who is still with us here, as an assistant public defender, is there anything that strikes you in what you have experienced in talking with different people about that employee side of things? We did hear your perspectives on expungements and how that would help people get jobs. How about when they are already employed?
You know, I don't really come into it until you get charged with a crime, right? So the focus has generally been on cleaning people's records off and letting them be available for jobs. And again, certain government benefits that are on here. I mean, the employers that I'm most familiar with, it seems like they don't really care what people are doing on their off hours, and they're kind of happy to have this taken off their plate. Sometimes there's rules in society that everybody follows, but the business owners would kind of prefer not to have to do this thing.
Now, I'd like to ask about the criticisms that did come up around the Legal Missouri campaign. In the lead up to the vote in November, there were some folks who voiced some considerable and quite vocal opposition. And these were folks not only from legalization activism circles, but also political figures like St. Louis Mayor Tishara Jones. Just a week before the election, Mayor Jones put out a statement that included the sentence, simply put, legalization does not equal decriminalization. Now, given that environment, what forward-looking takeaways have you gleaned from Amendment 3's victory?
Yeah, I mean, well, first, I think it is decriminalization. I think we've, Matt's points speak to that there are people's cases that are being dismissed and people being released from parole, probation. Those are important facts. Those are things that are really big changes for people going forward. And I would also say that, I think we kind of threaded the needle here because I think we created the broadest thing that could pass in the state of Missouri. You cannot just have an amendment that is pitched to progressives, liberals in the state of Missouri. That won't pass. This is a red state. You have to win conservatives. You have to win kind of libertarians on the right. So I think we've managed to get something that could bring together a coalition that spanned political ideology, and we carried 73% of the vote in St. Louis City, but we also we won St. Francis County where Farmington is, and we held our own down in Cape. It was 45-55 against, but you have to win a lot of conservatives to get 45% of the vote in Cape Girardeau County.
Did a lot better than the Democrats did.
Yeah. I mean, that's like an 80-20 thing, Republican Democrat down there. So we're winning Republicans, we're winning conservatives when we have those sort of results. And there's certain, you can't go too far and still keep those people in your camp.
Brian Pezza, an employment and labor attorney at the St. Louis law firm Lewis Rice, Matt Schmidt, an attorney and assistant public defender, recently based in St. Louis and now working in Cape Girardeau, and John Payne, the Legal Missouri campaign director who oversaw the winning ballot on the initiative Amendment 3. Thank you so much for joining us today and enlightening us with all of this background and information.
Thank you very much.
Thanks for having us.
You're very welcome.
This episode was produced by Danny Wysentowski.
Audio engineering and podcast design by Aaron Dorr. Our production intern is Avery Rogers. Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
Our podcast proudly supports St. Louis artists by using music from Life Creative Group.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations, and leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thank you.
St. Louis Public Radio is a member-supported service of the University of Missouri St. Louis.
Support comes from the Missouri Forest Products Association, providing more than 41,000 jobs in the production of wood pallets, railroad ties, white oak barrels, hardwood floors, and more. Details at choosewood.com.